Section 4. Trustee sale versus foreclosure. Don't default. Estimated instructional time, 6 minutes. Melissa walked into David's office the next morning carrying a purchase contract, but it wasn't the contract that had her attention. It happened, she said. David looked up from his computer. What happened? The homeowner from last week. The lender recorded a notice of trustee sale. David slowly nodded. So now the clock is running. Melissa pulled up a chair. I've always heard people use the words foreclosure and trustee sale like they're two completely different things. Aren't they? David smiled. That's one of the biggest misconceptions in Arizona real estate. They're related, but they're not the same thing. He reached over to the bookshelf and pulled out two documents. One was labeled promissory note. The other was labeled deed of trust. When someone finances a home in Arizona, they're actually signing two separate legal documents. Melissa looked at them carefully. The promissory note is the promise to repay the loan. Exactly. And the deed of trust? That's the document that gives the lender a security interest in the property. David nodded. That's what allows a trustee sale to occur if the borrower defaults. Melissa leaned back. So Arizona doesn't normally use court foreclosures. Correct. Arizona is primarily a deed of trust state. That means most residential foreclosures occur through a non-judicial trustee sale rather than a traditional judicial foreclosure. That's one reason Arizona's foreclosure process generally moves much faster than states requiring court involvement. Melissa nodded. I remember hearing stories during 2008. People in Florida waited years. Exactly. In Arizona, sometimes homeowners were surprised how quickly everything moved. David opened a timeline on his computer. The important thing for realtors isn't memorizing every date. It's recognizing that every week matters. The longer a homeowner waits, the fewer options usually remain. Melissa looked thoughtful. So once the notice of trustee sale is recorded, is it over? David shook his head. Not necessarily. A trustee sale hasn't happened yet. There may still be time. The homeowner may qualify for reinstatement. They may negotiate with the lender. They may pursue a loan modification. They may qualify for a short sale. They may even sell the property traditionally if sufficient equity exists. The key is acting before the auction. Melissa looked relieved. So recording the notice doesn't automatically mean the homeowner loses the house. No. But it should absolutely get everyone's attention. David paused. One mistake inexperienced agents make is waiting. They think they have plenty of time. The trustee doesn't. I guess that's why you've always said, hope isn't a strategy. David laughed. I've probably said it 1,000 times. He continued. In states that require judicial foreclosure, the lender files a lawsuit. The borrower has opportunities to appear in court, raise defenses, and the foreclosure process often takes considerably longer. In Arizona, because most residential loans are secured by deeds of trust, the lender generally exercises the power of sale through the trustee without first obtaining a court judgment. That doesn't mean homeowners have no rights. It simply means they have less time to exercise them. Melissa pointed toward the promissory note. So which document actually creates the debt? The promissory note. And which document secures the debt? The deed of trust. Perfect. Understanding that distinction helps realtors explain the process without practicing law. David leaned forward. Now let's talk about one subject agents often misunderstand. Deficiency judgments. Melissa smiled. I've heard agents say never has deficiency judgments. David shook his head. That's not entirely true. Arizona has some of the strongest anti-deficiency protections in the country, but they don't apply to every property or every loan. He explained that Arizona law generally protects many homeowners from deficiency judgments after qualifying trustee sales involving purchase money loans secured by certain 1- and 2-family residential properties meeting statutory requirements. However, refinance loans, home equity loans, commercial property, investment property, larger parcels, and other situations may not qualify for the same protections. That's why we never promise a client they'll be protected. We explain the general law, and encourage them to obtain legal advice about their specific situation. Melissa nodded. So even experienced realtors need to be careful. The fastest way to create liability is by giving legal advice outside the scope of your license. David stood up and looked out the office window. You know what separates great realtors from average ones? Melissa smiled. They know the law. They know enough law to recognize when someone else needs to answer the question. That's professionalism. As Melissa gathered her things, she realized the conversation wasn't really about trustee sales or foreclosures. It was about timing. Every day a homeowner waits after defaulting, available solutions become fewer. Whether the client ultimately qualifies for reinstatement, loan modification, a traditional sale, a short sale, or another foreclosure alternative often depends on how early they seek professional guidance. In the next section, We'll begin examining the practical alternatives available to homeowners after default occurs, and how experienced Arizona realtors can help clients evaluate those options before the trustee sale becomes a reality. Online discussion, discussion question 1. Why is it important for Arizona realtors to understand the difference between a promissory note and a deed of trust? Answer. Understanding the distinction helps agents accurately explain the transaction process without giving legal advice. The promissory note creates the borrower's repayment obligation, while the deed of trust secures the property as collateral and allows the trustee sale process if the borrower defaults. Discussion question 2. A homeowner calls after receiving a notice of trustee sale and believes it is too late to do anything. How should you respond? Answer. An experienced realtor should explain that recording a notice of trustee sale does not necessarily eliminate all options. Depending on the circumstances, alternatives such as reinstatement, loan modification, a traditional sale, or a short sale may still be available. The client should also be encouraged to contact the lender promptly and seek legal advice when appropriate. Discussion question 3. Why should Arizona realtors avoid telling clients they are automatically protected by Arizona's anti-deficiency laws? Answer. Anti-deficiency protections depend on several factors, including the type of loan, the property, how the loan was originated, and other legal considerations. Agents should explain that protections may exist, but avoid providing legal opinions regarding whether a specific client qualifies.